Folks, welcome to the Lunchtime Employer Handbook Happy Hour Zoom Spectacular featuring the fabulous five from the EEOC. My name is Eric Meyer. I am the publisher of the Employer Handbook blog at theemployerhandbook.com. I am also an employment lawyer. I don't make any money from blogging, so I have to do something to earn a living. I'm an employment lawyer at Fisher Broyles. You can check us out at fisherbroyles.com. But also, I am a mediator. I'm a paid private mediator, but I'm also a volunteer mediator for the EEOC, and that brings us all together today because we want to talk about EEOC mediation. And with me, I have some fabulous folks to help us along. So first, I want to introduce, I see Cynthia Lock on my screen, so let's introduce Cynthia Lock. Cynthia, tell everyone a little bit about yourself.
Hi, good morning, everybody. I've been mediating for EEOC for almost 13 years, and prior to that, I was one of our trial attorneys. So I'm just, an EEOC person all the way down the road, and I'm very happy to be here today and talk about our really good mediation program. So thank you for having me.
Thanks for being here, Cynthia. Next, I keep saying the fabulous five. I guess maybe I was including myself, in the fabulous five. There are only five of us. It's Eric Meyer and the fabulous four from the EEOC. Maybe someone else will just show up. Maybe is the chair going to show up today? Maybe. Who knows? You have to hang in there for the hour to see if Janet Dillon does show up today. But I'm not counting on it. Stephanie Moreno, how you doing today?
Hi, Eric. Thanks for having me. Good afternoon, everybody. I am Stephanie Moreno. I am the ADR coordinator for the Philadelphia District Office. I work alongside Cynthia in the mediation unit. I've been with mediation for a little over 10 years as the coordinator, having previously come from the litigation unit. And I want to thank Eric for not only his good work and good service with our unit as a pro bono mediator, but also for hosting the Fab Four today. And with his reference to happy hour drinking, anything goes during a pandemic. So day drinking's all good. And I hope you guys have poured yourself something good, whether it's bubbly soda or a glass of wine. Thanks for joining us.
And let's make it clear before we go any further that none of my esteemed guests are speaking necessarily on behalf of the EEOC. Isn't that right, Mary Tiernon?
No.
I have water on behalf of the EEOC.
Mary, why don't you tell everyone a little bit about yourself?
Hi, everyone. Thank you, Eric, so much for hosting us. I'm Mary Tiernon. I'm the Outreach and Education Coordinator for the EEOC's Philadelphia District Office. And our overall district, I don't know if we have people from our Baltimore, Cleveland, Pittsburgh offices. We sent to some other bar associations because the more the merrier. I've been doing outreach and training for, I guess, about 13 years. And before that, I worked with Cynthia and Stephanie in our legal unit. I have to say, although we're the Fab Four, I think Eric, an honorary EEOC, so the Fab Five, I may have one of the best jobs because I'm not in litigation and I just get to talk about all the wonderful things that Cynthia and Stephanie, the successes from the mediation program generally, not any specific cases, Dillon for all the great things that enforcement does and what we do in legal.
And speaking of Dillon's on the side of the EEOC firewall where most of our audience does not want it. I mean, if we're on mediation, okay, but at least we're trying to work things out. Dillon's on the investigative side. So when one of your current or former employees files a charge, it goes through Dillon. Dillon, why don't you tell everyone a little bit about yourself? Welcome today.
Thanks, Eric. So I'm the charge receipt supervisor. I'm a supervisory investigator. So I'm in the unit that receives every charge that comes in and provides notice to respondents once those charges come in. And in addition to that, I'm also like a really bad third base coach because I just send charges to ADR so Stephanie and mediators can resolve charges as expeditiously as possible. And in my free time, I'm a part-time 3L at Temple.
All right, nice. Nice. Now, when you're done, you going into employment law?
Yeah, I mean, it sounds moderately interesting. I'm joking. Absolutely, yeah.
You're gonna go over to the dark side? And I don't know which side is the dark side. You know, half the people would say it's the employee rights side. Some people would say it's management. Any feeling one way or another, or are you gonna keep it a mystery for now?
I think both sides are awesome, and I support both sides.
Sound like that. Thank you very much. We appreciate that. All right, folks. Real quickly before we get started, I'm going to share my screen one more time. I'm just throwing up a disclaimer. In addition to, folks, remember to keep your microphones off, keep your video off, don't share your screen. Got to remind you all that some of us are lawyers, and one of us will be a full-fledged lawyer in a year. But he's probably got the "it depends" wrapped down already. Like, we're going to say that a lot. But I just want to make it clear that none of us are your lawyers. And remember, folks, these people work for the EEOC. You know, keep your questions very hypothetical. Keep your questions very hypothetical. We'll answer them. We'll do the best we can. But you know, it's our pleasure to present this free of charge. But don't be stupid. Like, don't rely upon free legal advice. We don't give free legal advice. You know, don't never get that from the Zoom chat. If you want legal advice, go to your lawyer and pay for it. Okay. Perfect. All right, here are, oh, Philip's gone. I think he's got to go let someone in. So it's going to be the three of us for now, which is totally fine. Let me bring up my little script. Don't forget what I'm going to ask you. Stephanie, for the folks who aren't at all familiar with EEOC mediation because they've never been through the process, maybe they've never even had a charge filed against them, their company. Can you just tell us a little bit in very broad strokes what EEOC mediation is?
Sure. Mediation is what happens before the investigation is even begun. So charges come into the mediation unit right from intake. We do not weigh evidence. We don't seek evidence. It's a neutral process with neutral mediators who have no stake in the outcome. They're simply there to facilitate dialogue between the parties and hopefully bring both sides to an amicable resolution. We're going to be speaking a little later about the new ADR pilot, but it has broadened the scope of the charges that will be coming into ADR. And now all charges that come in the front door of the Philadelphia District Office and all of the EEOC offices across the country will be offered mediation.
That's great. You mentioned, Stephanie, and I guess maybe I'll flip this over to Cynthia a little bit, because Cynthia is one of the mediators who handles these on, pretty much on a daily basis. Cynthia, Stephanie mentioned about the EEOC facilitating the mediation process. Can you tell everyone a little bit about the facilitative mediation, facilitative mediation and how the EEOC employs that?
Is that for me, Eric?
Yes, for you.
Okay. Well, I think we focus on the fact that we are neutral. When we say facilitative, we do, during the private caucuses, do a little bit of, perhaps what we call reality checks or risk analysis. But ultimately, we don't put numbers on the cases. We don't come on as strong as a magistrate would. Our goal is to facilitate the process among the parties, and whether it resolves or not is the party's final decision. We offer a forum, we offer them a chance to converse, and we basically guide the process.
Neither side has to have a lawyer, right?
Correct. Either side can be unrepresented. I think Stephanie would know the stats better, but I think probably once I looked at it, I noticed that maybe about 25% of the charging parties are not represented, if that. But lawyers are not needed. Respondents occasionally will have an HR manager or just a company representative there. It's absolutely fine either way.
Well, for the 25% of charging parties that aren't represented, there's always the law firm of Google and Bing. I end up encountering that every once in a while as a volunteer mediator. And that's true of both sides, whether they have counsel or not. Sometimes expectations can be a little inflated. How do you deal with that, Cynthia, when you know, it's your first, you know, might be someone's first time ever at EEOC mediation. How do you deal with setting expectations?
Our staff mediators, when we schedule a mediation, before we even schedule it, when we reach out to the charging party that's unrepresented, we start the process of adjusting expectations then. You know, we try to get a feel for where they are. If they tell us off the bat that they want the world to know, or that they want $1 million, or that, you know, they appear really unreasonable, we have the ability to actually not allow someone to mediate with us, because it's got to be voluntary by each party and by EEOC. So we do our best to prepare them, and, you know, really the people that we think will be unreasonable or will not negotiate properly just are not in that place. We have, if we really can't talk them into a mediation worthy place, we don't have to allow them to mediate. But anytime you are mediating with us and an unrepresented charging party, you can be sure that the scheduling mediators have really tried to adjust their expectations from the initial phone call and spend time with them. Of course, we can't guarantee what they will say when they walk in the door, but that's one of our missions, to give our mediations the best chance of success.
I once represented a fast food franchise that caught the charging party, or complainant, because it was before a FEPA, a Fair Employment Practice Agency, a state one, on video, beating the holy hell out of a female coworker. So we fired him. And we ended up going to mediation nonetheless. And he demanded, going into the mediation, $5 million. He wanted the manager who fired him fired. And he wanted a positive reference letter. It was the positive reference letter that turned me off from mediating, not the $5 million. So we never mediated. But I get your gist about setting expectations. But
it doesn't always work.
No, it doesn't.
Right.
But Stephanie, go ahead. Yeah.
It's important to point out too, whether represented or unrepresented, the most important part of our mediation process is that it's confidential. So the $5 million demands, the positive reference, what either side says or suggests during the mediation process, it's like Vegas. What happens in mediation stays in mediation. And there's a very strong firewall between the mediation unit and enforcement. So I want to make that clear for the folks out in virtual land who may have never utilized our mediation process, that it's a good opportunity for early resolution, which could be a good business decision for a respondent, or also a way to finalize life events for a charging party who's been dealing with employment issues for some time.
Yeah, Stephanie, it's kind of like, it's like your day in court without it really being your day in court. And if we do it right, it's the closest you're ever going to get to your day in court, although we're not dispensing justice, right?
It couldn't be said any better, Eric. Thank you for bringing that up. We do liken it to a day in court because the parties at the beginning of the process have an opportunity to sit down together in a joint session. Each side gets to tell their side of their story, and it can be cathartic for a charging party. It could be the first time maybe a respondent's hearing about things that were going on or perceived as going on, and the parties can look each other in the eye and really have that, as you put it, a day in court. And that sometimes can, even without the parties realizing it, bring them closer to a resolution just to get it out there and have the other side hear it.
Yeah, I have a little note on my agenda to talk about kind of some pro tips and best practices. We have a largely respondent audience, maybe not all, but I'm gonna sneak one in here right now. Folks, when you go to mediation and we're in that group session, whether we do it in person or online, offer an apology. I don't care what you're apologizing for, but offer an apology to the charging party. Make it sincere. You're not admitting fault, but just apologize. That can go a long way. It's not going to get you out of writing a check, more likely than not. But the reaction you'll get, you're just going to put the charging party, you're going to catch them flat-footed, and it's going to be received well. So please, I encourage respondents, whether it's through their counsel or even better, directly from respondent self, offer an apology of some sort, because no one really wants to be at mediation. It's just an unfortunate situation. But it's a great opportunity to get the matter resolved. Stephanie, you were alluding earlier to the success of the EEOC's mediation program. And before we go to Dillon to talk about the pilot program, as it exists right now, the mediation program, how successful is it?
So we have a very successful program. Our resolution rate is always high, and that doesn't mean that we're there. We've explained that we're really there as neutrals, but I think both parties benefit from the process that we offer. Currently, and I have some few statistics available, just through July of this year, our fiscal year starts October 1st. So from October 1st of 2019 through this year, the district, which is comprised of 4 offices in 3 states, Philadelphia, Cleveland, Baltimore, and Pittsburgh, we've held 738 mediations, and to date have resolved 558 of them. Just Philadelphia alone, we've mediated 291 and have resolved 249. By comparison, last fiscal year, from October 1 of 2018 through September 30th of 2019, the district held a total of 764 mediations and resolved 645. Philadelphia alone was at 283 mediations held and 281 resolved. So that's a whopping statistic. The numbers seem awfully close, considering that for the statistics I offered for this year was up through July. Everyone has to remember last year the government was shut for a full month, so we weren't able to mediate. And so last year's numbers seem relatively close to this year's numbers, but we lost a whole month of mediation.
Mm-hmm. Dillon, things are changing a little bit. We're not just mediating. We've got this new pilot program that changes mediation. It sounds like for the better. And just before we get to you, Dillon, I want to make clear to the audience a couple things. One is, if you have questions, please post them in. There's a chat option at the bottom of your Zoom window. Please put questions up there. We're going to answer them. So far, it's pretty quiet right now, but we'll do our best to answer them. Second, I want to emphasize that while we're maybe focusing a little bit on what happens in the Philadelphia District Office today, EEOC mediation is available nationwide. So the approach to mediation, we're going to talk soon about remote mediation that EEOC is conducting. This generally applies, as far as I know, across the country. Maybe your mileage may vary just a little bit, but this is generally applicable whether you're in Philadelphia area or in, I was going to say California, but it's probably something weird and different in California. But pretty much anywhere else in the country, it's probably pretty much the same. So, Dillon, tell us a little bit about what's going on with this pilot program.
Sure. So, I think the commission, the chair, recognized the success that mediation has been for the agency, for the parties. I think they've seen the successes for individuals and for respondents, and I think capturing the successes that were already built by the ADR program. I think she saw that maybe some charges weren't going, or as many charges that we could send to ADR were going to ADR. So essentially what she had told us in enforcement at the intake unit is every charge is eligible for mediation unless somebody in headquarters, a senior official of the EEOC, for whatever reason has deemed a charge ineligible, which essentially, and since most folks in headquarters aren't looking at our charges, almost every charge is going to be eligible for mediation, and that was effective July 6th. And so what that means is respondents are given the opportunity to select mediation as an option prior to responding to a charge. So while they might receive a notice of charge that will ask for a response within 30 days, if they select mediation and mediation is, scheduled and held, then there won't need to be a response to the charge. And, that firewall between enforcement and intake will mean that anything done in mediation is done in mediation. And if it's unsuccessful for any reason, it'll come back to enforcement where, we could still conduct a settlement conference if the parties wish to resolve the charge through enforcement. But, every charge that comes into our office and in the district and in the agency is going to mediations, getting that opportunity for respondents to, choose mediation, for the charging parties to choose mediation before any, further investigations ever done on the charge.
Okay. Can you give us an example, Dillon, of the type of case that before the pilot program might not have made it over to mediation because maybe the respondent wasn't offered the opportunity to mediate?
Sure. So, sometimes the charging party's attorney might draft in a charge that there might be a small class of charging parties. Sometimes those cases we wouldn't send to mediation because we would want to see perhaps if there is a class. But in this case, if a charging party's attorney submits 4 charges on behalf of 4 charging parties identifying a class, the charging parties and the respondents can resolve all the charges all at once now. And I think that's going to be something that's helpful to respondents and to charging parties as well, is that folks don't have to wait as long as they would have had to for an EEOC investigator to negotiate that settlement between the parties.
Okay. Stephanie just answered a question in the chat window, and I want to make sure everyone sees this. Is there a cost? We should have said this at the outset. Is there a cost to mediation? The answer is absolutely not. I mean, the only cost you have as a respondent is your time. And if you want to bring a lawyer, his or her hourly rate or flat fee, whatever they charge. But the EEOC does not charge you anything to mediate. It is free. And it's, you get great value for it because worst case scenario, you spend a few hours at the district office or now you'll do it remotely and you can end at any time. You're not tethered there. Both sides go in good faith, and if either side wants to call it a day, that's it. So,
Eric, if I can add right now, you raised video conferencing. With the pandemic, all of our mediations are now completely done remotely. We use multiple platforms, including Zoom, and we're getting incredible feedback from the parties, especially Respondents Council, who may have to, under normal circumstances, fly folks in from all around the country. Now everybody can tap in from wherever they're located, and it's really, like I said, getting a lot of positive feedback, and we're seeing an uptick in parties who wish to mediate because of that ease. And Cindy later on will speak about some of her success stories with the virtual platform.
Yeah, I love remote mediation. I've done it as an advocate representing management. I've done it privately as a mediator. I've done it for the EEOC as a mediator. We'll spend much more time on it in the second half of this Zoom, but it's just as effective, I feel. Takes a little bit longer for whatever reason. We can kind of speculate why, but we get to a resolution. I mean, I think our success rate is as good. Hey, Dillon, what would make, under the new pilot program, I mean, I think you touched upon it, if a commissioner or someone on high wants to pull a case and say it's not eligible for the pilot program, is there any specific criteria that would make a charge ineligible, or is it just on a case-by-case basis?
So generally speaking, it would be a case-by-case basis. But, a commissioner's charge, an investigation that was directed by the director of an office, those seem to be the only ones at this point. If a commissioner files a charge and the commissioner does not want to engage in mediation, then a commissioner's charge will not be going to mediation.
This is just a joke, folks. But if the respondent, if you work at like AutoZone or Texas Roadhouse, maybe those are the ones that seem to pop up on the in the newsroom, maybe you have a little trouble there. I'm sure maybe even now those entities can go to mediation too. Just a joke. Probably a bad joke. So if I am in, I decide at first I don't want to go to mediation. I represent a respondent. We get a charge. We're offered mediation. We talk it over. We decide, you know what? Don't want to do it. Let's just file our position statement instead. So it stays on the investigative side of the house. EEOC is doing an investigation. There might be some document and data requests. Maybe at some point a fact-finding conference. It's getting a little bit more than we bargained for. Can we kind of, raise their white flag and say, hey, let's mediate? Does it work like that, basically?
It can. So if the charge is in enforcement, the charge can be transferred back to the ADR unit. However, there's only going to be one bite at the apple. But still, even if the mediation is held during the investigation, the EEOC investigator may be involved, and in that case, that information will not be confidential. So it kind of incentivizes accepting mediation early on. And the other side is, even if mediation is not offered during the investigation, EEOC investigators are empowered to facilitate negotiated settlements. So if the parties are, wishing to engage in some sort of settlement discussion, the EEOC investigator can reach out to the other side and say, are you willing to resolve this case and help the parties reach resolution? Not the way mediation does, but, I've had a fact-finding conference that quickly turned into a settlement conference because it was just misunderstanding. And the manager and the charging party ended up hugging, and it resolved the charge off of a hug. So even though it was in an investigation, we were trying to find out if discrimination occurred. Just by talking it out at all stages is an opportunity to resolve the case.
Yeah, I'm going to offer an early pro tip to the audience here. Don't count on settling the EEOC mediation with a hug. In fact, that could inspire a retaliation charge. So, if you can get away with it, okay. But, that's a cool one, though. Someone asked me privately, if mediation breaks down and one party ends the mediation, can legal action move forward? And the answer is yes. If the mediation doesn't result in a resolution, well, let me put it the other way. If mediation results in a resolution, part of that resolution involves the charging party dismissing the charge. And usually there's a general release that's signed as part of it. So usually any claim that the charging party would have is gone in exchange for some form of consideration, usually money. But if the mediation doesn't result in a resolution, then the matter goes back to the investigative side. There may or may not be an investigation depending on a number of factors, and one of which is the charging party could request a notice of right to sue, in which case the EEOC might close its investigation altogether at the request of the charging party. The charging party would then literally get this notice, and then they would have 90 days in which to go to federal court to file, well, presumably federal court, to file a lawsuit under one of the federal EEO laws that the EEOC administers, such as Title VII, such as the ADA, such as GINA, for example. So that's what happens if mediation breaks down. Does that mean that the parties can never settle, privately or amongst themselves? No, they certainly could, but yeah, more likely than not, you're getting closer and closer to legal action, to an actual lawsuit. Is there anything else about the pilot program that you think our audience should know, Dillon?
Yeah, it's just a super helpful way for all charges that are received between July 6th and January 2021 for charges to go to mediation first without any blockage. They're all going to mediation. Parties are given the option to mediate the charge as quickly as possible or resolve the charge as quickly as possible. And even then, the parties aren't left with just that one opportunity to resolve the charge. Parties can, like you said, resolve the case during the investigation privately or with EEOC again. as a partner in helping to resolve those cases. It's just interesting that what I think is a big takeaway is that the chair saw how successful mediation was and said, let's make this, agency-wide, let's make this possible for the next 6 months. And just to really highlight the effectiveness of EEOC mediations.
Eric, can I jump in real quick?
Sure.
It's important to note something. Because of the pilot, they've changed the portal a bit, and there's no end date for the mediation response. So what the Philadelphia District has done internally to stay on top of our incredibly large inventory is we're giving a 15-day window to respondents to make their mediation election. Previously, the portal would say respondent has to elect mediation by a date certain. So without that, we send a marketing letter just reminding them of their obligation to make a mediation election and giving them that 15-day window date. Otherwise, we can't have a backup of cases sitting without a mediation election. So on the 16th day, they're getting sent back to enforcement if we do not receive a response. And that's really important for the folks out there to know.
Yeah, I mean, one of the big reasons to do mediation, in case we haven't emphasized this enough as a respondent, is it avoids the cost and time and expense of having to do a position statement, right? So think of everything that goes into the position statement, even if you do it yourself, right? You've got to review files, you've got to presumably interview people, conduct some sort of an investigation. If you're using outside counsel, they're going to have to do all that. You're going to get lawyer bills. So you're spending, it could be several $1,000s on an investigation, which I guess you probably do anyway. But also the position statement, where the alternative is you can just go to mediation, you go in good faith and you're prepared, but that money that you would otherwise pay to outside counsel, you could maybe even spend less just paying the charging party and getting this done with and getting peace of mind and moving on. Because odds are, most of these cases, if they go beyond mediation and they go to litigation, they're not going to trial anyway. They're going to get settled. So, better off to settle now rather than spend less than settle later. I mean, those of you who have EPLI, Employment Practice Liability Insurance, I mean, your carriers are probably big fans, should be big fans of EEOC mediation because of the early opportunity to get these matters done for cheap, or potentially cheap. So, keep that in mind. Cynthia, we talked a little bit earlier about how we're not doing this live anymore. If we were in Philadelphia, we'd be going to 801 Market Street to do mediation in the lovely, actually there's some new dates actually that the EEOC has at 801 Market Street. I haven't even seen them yet. But we'd be at 801 Market Street and we'd be doing this in person. But now, Cynthia, we're doing them remotely. How has that gone for you so far, doing them remotely?
I mean, for our agency as a whole, as Stephanie mentioned, it's gone very well. Our numbers may have been a little bit lower in the beginning, but we have kind of like a secret asset in the fact that, like you, Eric, we have a good number of very qualified volunteer and contract mediators. We have 26 and 16 of them have come on board for virtual mediation. So now we're able to do, in recent months, even more mediations than we did before. So it's really blossoming in that sense. I would say, as far as the remote mediations, our success rate remains high. There are, of course, like you'd expect in anything remote, people experience some technological issues with, video and sound and things that can cause it to be delayed. On the whole, it's working very well. I recommend attorneys to try to have their parties participate by video instead of just telephone, because it gives you that personal link and it gives you more of a connection than if you were just on the phone. And also reading faces, looking at people. I think it's harder to walk away when you're at least virtually present. It's going very well. One of the challenges is getting the parties to sign the agreements the same day, because oftentimes when you're doing virtual, people will wander away and they'll leave it to their attorneys to close it at the last minute. So we do encourage the people to keep their clients around to sign, because that's what gives the parties a sense of closure. If when one agreement has been signed and then our agreements have written into it an additional length of time for the private releases to be supplied. So we try to encourage that. All in all, the main challenges are like taking a little bit longer and the issues that we might have with technology. But I think that people are going to say, as Stephanie said, that they are satisfied with it and may even want to continue doing virtual when it's not a requirement as it has been now.
Do you still conduct the opening session as a group when you do it would you do it remotely?
Yes, we do. We do conduct opening session in the same way. And as in the in-person mediations, we do invite parties to do the opening comments. And I know that can be kind of a controversial topic in terms of the opening comments. Some attorneys like to and some don't, but we do recommend that something be said. So we have the exact same opening comment and we have the exact same private caucuses. We currently use Microsoft Teams, a little bit different than Zoom, but our volunteer mediators can use Zoom or WebEx. And the commission hopefully maybe will be moving over to Zoom. So, you know, we offer a lot of opportunities.
Yeah, when I've been doing it, I've been doing it using Zoom, and I just set up some breakout rooms for the parties. That's gone pretty smoothly. I echo your sentiments. I think for me, the extra time it has taken, I don't know that it's so much technology. I find that each time we do it, or I do it, I get better at kind of getting people in their breakout rooms and getting it all set up. But maybe it feels like the parties spend a little bit more time caucusing privately with their counsel. And what I often do is I'll give the attorneys my cell phone number and they just text me when they're ready to talk. So I feel like maybe me personally, I have a little bit more downtime as the mediator. It's also nice because I can go make lunch when I really could never do that at 801 Market. But anyway, but nonetheless, the process itself is largely the same. And I agree with you, Cynthia, that to the extent that we can do it on Zoom or Microsoft Teams, or you can see someone, it is a lot more effective because you can look someone in the eye and really create more of a personal bond. Although I get it, and I guess it's more with charging parties where, you know, some people just don't have access to high-speed internet. They don't have the wherewithal to log in using Zoom or any form of online portal. So you have to do it with telephone. And in that situation, you know, if it's both sides that have counsel, usually counsel will set up a conference call number that I'll dial into each time I go back and forth. Or if it's just, you know, pro se, I'll call them and charging party, we'll get it done. But you know, we get it done.
Yes, and sometimes like what Dillon was mentioning, you know, the apology, it's really difficult. It's better to do that in person, seeing the other person's face. And like Dillon, we have had experiences like that. As long as it's a sincere apology said by, Mary shaking her head, it has to be sincere. Like, you know, we could have done this better. You know, it's just got to be addressed sincerely. If it's just a fake apology, it may not carry much sway, but especially if it's said by a company rep instead of an attorney, you know, directly to the charging party, and it's real, I've seen it be very effective. And that's why I always recommend as much face-to-face as we can get. But I will also say that the virtual mediations can inspire creative solutions in the sense that charging parties who can't participate by video, don't have a scanner or a printer, they're signing with screenshots from their cell phone. So, you know, we're getting it done.
Yeah, totally fine. I'm totally fine with that. I mean, and the nice thing too about what I'll call virtual mediation, that's not fair to call it virtual because it's real mediation. I mean, virtual is just like we're not there physically present, but I mean, I'll share documents on my screen using Zoom. People can email me documents and I can share them with the other side. I mean, it's really seamless. And you know, if someone is in the office, it's more likely that they'll have access to particular documents that they wouldn't otherwise have at the mediation. I mean, usually these mediations aren't document intensive, but you never know when something like that's going to come in useful. So I find that very helpful when we do it remotely too.
Yeah. I feel like one advantage of the EEOC mediation is that you can select which documents you want to send. If you wait until litigation and you get your subpoenas and requests for production, you are forced, you know, you are ordered, unless you can create objections, to submit documents you may not want to, but you can just bring one or two compelling documents that will help your case and share them in mediation. You get to pick and choose. Whereas you couldn't do that in court.
Yeah. Do you, I know as part of regular in-person mediation, the EEOC does not request, and frankly, I don't think doesn't want any sort of mediation statement from the respondent. Does that hold true if you're doing it remotely too?
It's the same. You know, we don't, there are many reasons for that. You know, some is because we do use so many pro bono volunteer mediators. We don't want to burden them with that beforehand. We encourage people to provide all the information at the mediation. We also encourage them to exchange a demand letter with content, and the respondent can always provide a substantive letter to the other side prior to mediation. But they can't provide, we don't accept the private statements that are only for the mediator pre-mediation. And the other reason for that is that often people are unrepresented, so it would give an unfair advantage.
Yeah.
And similarly, I'm sorry, Eric.
No, go ahead.
Similarly for the position statements, we're not reading position statements if they're submitted prior to the mediation, and parties often request the opportunity to submit mediation statements. And as like Cindy said, we do not accept them. We don't want them. We don't want to read them because the mediators are neutral and everybody is going to be on the same playing field.
Yeah, what I do when I serve as a pro bono, what I'll do is I try and do ones where there's counsel on both sides. So what I'll do is I'll set up a pre-mediation call with counsel, and I'll work through some of these logistics. It takes about 15 minutes max. I encourage them to make a demand and an offer going into it. I explain to them a little bit about facilitative versus the evaluative mediation process. I also try to find out whether there's anything beyond the four corners of the charge that may need to be resolved. I know the EEOC is only supposed to resolve Title VII and ADEA and ADA, but you know, if there's an FMLA claim lurking because there's an ADA charge, or if there's a wage and hour claim, or if there's a counterclaim, I want to know about it going into it, because if it comes up as a surprise at mediation, it just throws a monkey wrench. And like, yeah, technically I'm not supposed to resolve it, but in reality, we're going to resolve it. So I'd like to know in advance. Plus, I also want to know if it's a current employee, you know, if the respondent's position for mediation purposes is that this person's going to need to resign. For mediation purposes only, I need to know that in advance of the mediation, because bringing that up on the day of mediation, that as a condition of settlement, this person needs to resign, you're not going to get that case settled. It's just not going to work. So I like to find out as much of this stuff in advance as I can without going to the extent of asking for mediation statements, because probably like you, I get the charge when I mediate for the EEOC. I get to charge day of. Or if I get it the day before, I'm probably not reading it until day of. So I read it, I get a sense of it, and then boom, I'm going right into the mediation. There's a couple questions that have been asked, and I want to make sure I'm getting to these. And I'm going to turn it over to Mary Tiernon, who's been sitting there silently lurking. What does she have to say? She's going to talk a little bit about some of the other EEOC outreach programs that I think are great for employers right now. A couple questions. Someone asked, if the respondent misses the 15-day window to request mediation, is there a way to submit a mediation request after the window has passed? Stephanie, Dillon, how do we do that?
Just whoever the case is now pending before, your new contact in the portal, just simply say you'd like it to be sent back to mediation. If it's with an investigator, they'll bring it to my attention, and depending on resource and other factors, that determination can be made. Also, they can reach out to me directly or my program assistant, Shirley Wern. And people are getting used to the pilot, so that 15-day window is getting missed by a few days, and we're just very successful in bringing them right back. But we do ask the parties to try and stay within that window to prevent the back and forth from mediation to enforcement.
Let me put one caveat on something you just said, Stephanie. If you're in the Philadelphia district, if you have a charge pending in the Philadelphia District Office, you can reach out to Stephanie. If you have a charge pending in Missouri, don't reach out to Stephanie.
Correct, correct. And of course, despite being the ADR coordinator for our district, we have contacts in the other offices that you would reach out to. It's Jean Klickner in Pittsburgh, Samantha Regal or Chayton Patel in Baltimore, and Deanna Jackson in Cleveland.
All right. Stephanie answered one other question. Someone had asked, is there only one way to do the mediation? Specifically, is there a second day? Is it possible to do a second day? And the answer is yeah. The charge gets, or the mediation gets marked as pending, and then there's an opportunity to regroup. As the volunteer mediator, I'm not the biggest fan of second days, but I'll do it if I have to. I like private mediation where I'm paid. Second days, those are good. Keep them coming. Mary, can you tell us a little bit about some of the other education outreach that the EEOC's got going on that can benefit employers along with this, EEOC mediation and pilot program we've been talking about today?
Thanks, Eric. So we've also been doing outreach virtually, either through Teams or sometimes on other people's platforms, WebEx, like Cindy mentioned, and we're piloting Zoom for outreach as well. So that's a nice additional tool. We have some things, free outreach, we can give overviews. Sometimes it could be to stakeholder groups. It could be to employer groups, SHRM groups. We've had a lot of requests for updates, EEO laws in light of COVID-19. So that's been a hot topic. And we still offer paid training in different ways. We are piloting, I'm going to be rolling one out in the next few weeks, actual training for employers and employees virtually at an employer's work site. And one of the things that we usually do is have one-day seminars at hotels, bringing employers, HR representatives together to hear the latest updates. This year we're going virtual, and we're excited the opportunity to go virtual. We can partner with the Indianapolis district. They kind of headquarters divided us into partnering, and we share the state of Ohio. So we get to partner, which makes it more exciting instead of just our usual Philadelphia or Baltimore. And Eric is kindly going to be speaking as one of our presenters, and that's going to be on September 29th. And one of the many reasons I love my job, hearing my colleagues, but I thought there's an overlap from what you talked about and some of the things that we talk about in training. One of the big things that's been a huge success, I think, for us training over the last 2.5 years, respect in the workplace, or leading for respect. And we developed as an outgrowth of the Select Task Force on Harassment Issues. One of the things that the panel and the then chair and commissioners realized was the role of respect or lack of respect and how that can escalate into harassment. And so one of the suggestions, they encouraged employers to talk about civility, talk about respect, talk about the role of bystanders, how if they feel empowered and safe, can really change the culture. And we also now have a leading for respect or respectful workplace, leading for respect for managers, supervisors, respectful workplace for employees. And the overlap, I think, with mediation, what you talked about, setting expectations. I mean, it's a way for employers in the training to talk about what the expectations are, expectation that everybody will be civil, respectful. We don't have to like everybody maybe at work, but we can all be professional, and whether it's in the virtual setting or back in the workplace. And the role of listening, like you all said, and that you do so well as pro bono or paid mediators. And a sincere apology. Sometimes that makes a big difference. Like you said, Eric and Cindy, not one of the, well, I'm sorry if you have no sense of humor, things that's going to make everybody feel worse. But there's such an overlap. And I feel that what we do in outreach is the same with mediation. One of the great things, the advantage trying to resolve things before maybe a prolonged investigation. At the commission, we feel strongly about outreach, and I'm fortunate that I can do that full time, but as you can see, Dillon, Stephanie, Cynthia making time to do outreach as well, because our current administration, our leadership in Philadelphia, we believe very strongly in the role of proactive prevention and trying to let people know about their rights and responsibilities. And if we can stop things from escalating, like the example you said of sometimes things being a misunderstanding, if we can let people know, the realistic expectations and what the responsibilities and rights really are, a lot of times that is powerful and maybe can prevent things from escalating to even have to get to a charge stage.
You mentioned, you mentioned how this isn't just your normal run-of-the-mill anti-harassment training. I want to emphasize that. I've seen the curriculum. Bystander intervention training is involved in that as well, correct?
Yes.
Huge. Does the EEOC incorporate some of the DEI principles, diversity, equality, and inclusion into the training?
Yeah, I guess you would say generally on that, and maybe I probably should ask to clarify what you mean with the DEI, because I could have that in my mind and I might not be thinking exactly what you're thinking.
Well, it sounds like it does. I mean, just going into respect, you're not so much focused on just the EEO laws, but basically, how to, when I say inclusion, I'm talking about, I use the kind of the analogy of diversity is inviting everyone to the dance party. Inclusion is then asking people to dance at the dance party, and equality is like, you don't care what people think of, what people think of you when you're dancing, because everyone just feels equal. So do you have, part of that kind of that metaphor type going on there?
Yeah, and that's, I wanted to check, and I love the dance analogy, and
I didn't make that up.
I know you did. No, we've heard that, but hey, we're here for our happy hour dance party. It's all good. And I think one of the powerful things that we talk about when we have it is, it's not us coming down as this is what we think respect means. It's, one of the exercise, what does respect mean to people? And there's such an overlap of what we hope for, how we'd like to be treated, how we'd like to treat other people, whether you're working remotely or in the office. But there's such a powerful dynamic when people come together and talk about it. And I think that from the ones that, I haven't done virtual ones on the respect so far. Some of my colleagues haven't pioneered it. And particularly with the Zoom breakout rooms, it's been going well. From the ones that I did in person, I think it's been the most rewarding thing that I've done in the last 13 years, and a big part of my overall career with the EEOC, because it's just been so well received, and for people to have the opportunity of feeling heard and maybe realizing, voicing concerns that maybe managers aren't aware about. It's just, it sounds very simple. Respect seems very obvious maybe until we start talking about it. When I think of this training, I'll be honest, I thought about how I would like to maybe give the gift of feedback to people, not anybody in the district, sometimes a friend or outside of work, And the more I did the training, I realized it's really a mirror. You know, I feel like it makes us think about, well, what is my role in this interaction? What has my role been in this relationship? How can I improve? And, you know, if somebody's told me about a concern, or knowing that someone has a concern, how can I respond and be different in that work relationship? And I just think that it's been, and the trainings are either 2 or 3 hours, usually the ones that I've done. It's amazing how powerful that conversation can be in a short period of time. So not to make it a total commercial plug, I did the commercial plug as well for our seminars on September 29th, and you can go to eeotraining.eeoc.gov. You could reach out to me, Eric, I think maybe could share, or maybe I'll put it in chat. If anybody has issues, questions about free outreach or training. But it's, you know, going back to the listening, the expectations, and respect. And if we have that as a bedrock for everyone, wouldn't that make just such a powerful difference in our workplaces and our society?
Yeah, and for folks that are, you know, for everyone who's still on here, I am recording this. I'm going to post this to YouTube on the Employer Handbook YouTube channel. And in the description below the video on the channel, I'll put links to information about Mary just posted something in the chat about her email address for outreach, but I'll post that in the description. I'll post links to EEOC training, to mediation, to the EEOC's general website, so you'll have that. We have a couple minutes left, 2 minutes left. I don't see any pending questions, so I'll give anyone a last chance to lob something in if they want. Otherwise, I'm going to let everyone make some closing remarks if they'd like. Cynthia, anything else you want to add?
Yeah, I just want to say that if you haven't participated in our program before, if you have doubts or concerns or something that you want to ask, please reach out, because we're happy to explain anything to you. And I'll also put my email in there as well.
Thank you.
Work with you on any questions you have.
Thanks, and thanks for being here today. Dillon, thanks for your time. Anything else you want to add?
No, just if you have any questions, feel free to reach out to the office, and you know, we'll answer any questions that you have.
Stephanie, any we were talking earlier about you want to mention the Metallica drive-in that's going on, or
Yes, my love for Metallica precedes me. Go to your local drive-in on August 29. Tickets are on sale today. That aside, please elect mediation. It's a no harm, no foul approach to hopefully an early resolution. We're here to serve you guys. You may be lucky enough to get Eric as a pro bono mediator. We hope to see you all in mediation, hopefully sooner rather than later, at our new digs at 801 Market, 10th floor, no longer the penthouse. And thanks for joining us today.
Thanks, and thank you everyone for turning out. Again, we're going to post this to the Employer Handbook YouTube channel. My name is Eric Meyer. In case you didn't know, I am the publisher of the Employer Handbook blog at theemployerhandbook.com, and a lawyer at Fisher Broyles, and yes, I am a private mediator and a volunteer EEOC mediator as well, and every once in a while I do get some sleep. So again, thanks everyone for your time, and hopefully everyone have a great weekend. Stay safe. Bye.
Thank you, Eric.
Thank you.
Fab 5.